Share with my screen. Okay, criminal procedure. So, you said until motion po kayo, right? Motion to quash. Tama po ba? So, we have prosecution of civil action, preliminary investigation, arrest, bail, arraignment and plea, motion to quash, and meron ba yung kasunod? Yung pre-trial, trial, judgment, motion for new trial and reconsideration, appeal, search and seizure, and so on and so forth. Pero, since you said motion to quash, um, pero yung itatakal natin ngayong gabi is possible nearest that will come out in your exam tomorrow. And let's make it simplify. Starting tonight, focus only on the basic principles. If you master the basic principles, any subject, any topic, basta basic principles po, i-master mo. Because ang itatanong lang, though complicated siya kung titignan, just like what you've experienced sa statutory construction, pero kung ma-observe mo, ang isasagot mo doon is basics lamang po. Okay, so ikaw na bahala yung magmaniobra yung sa English language, yung sa logic. Kasi, to tell you honestly, pwede naman pumasa kahit hindi ka though kailangan ng legal basis, pero madali po madidetect ng mga professors at saka mga nila attorneys if may logic po ang sagot. Okay? So, um, ito na, I'll explain to you later on. Sige, criminal procedure. So, pag sinabi pong, um, when it comes to the criminal jurisdiction and also distinguishing jurisdiction over subject matter from jurisdiction over person of the accused. So let's recall, pag sinabing, okay, subject matter. Okay, basics muna tayo ha. Subject matter and person of the accused. Okay, okay, so dalawa yan. So subject matter and person of the accused. What do you mean by subject matter? Pag sinabing subject matter, it is conferred by law. Okay, pag sinabing subject matter, it is conferred by law. At pag sinabi namang person of the accused, this person charged must have been brought, dinala siya sa court. O, pag sinabing person of the accused, dinala siya sa court. Pag sinabing subject matter, conferred by law. And other terms po sa subject matter, it is the authority to hear and try a particular offense and impose the punishment for it. So since the subject matter and the conferred by law, it has the authority to hear and try a particular offense. Okay, pag sinabing a person of the accused naman, it is the authority of the court over the person charged. So, you just have to write or take down notes yung mga important matters lang. Okay, um, so sa subject matter din, it cannot be conferred upon the court by the accused. Kasi subject matter eh. Subject matter. Pero, when it comes to the person of the accused, as a rule, one who seeks an affirmative relief, such as seeking for the dismissal of the criminal case, is deemed to have submitted to the jurisdiction of the court. So let's simplify it. Pag ito, requisites for exercise of criminal jurisdiction. So ito ha. So sa criminal jurisdiction, jurisdiction over the subject matter. Okay? So, di ba, meron tayong subject matter, we have your territory, pero those jurisdiction of this over the territory, venue is jurisdictional. Okay, pakilagay sa iyong notes, venue is jurisdictional. So, ang jurisdiction over the person of the accused, pag sinabing jurisdiction of the person of the accused, it has the authority of the court over the person charged. So the court, meron siyang hawak dito sa person charged because it requires the person charged with the offense must have been brought into the forum for trial. Okay? Gets po ba? Okay. So let's go to parang bumalik tayo sa civil procedure pero since wala ka pang civil procedure, ito yung sa basics ng civil procedure. So, let's say for example, municipal courts, 'di ba? We know municipal courts if you read the batas pambansa of the jurisdiction of the courts. So, for example, sa municipal courts, it has exclusive or regional jurisdiction over offenses punishable with imprisonment not exceeding 6 years. So, wag na lang yan. Um, And also for the regional trial courts, it has the exclusive original jurisdiction in all criminal cases, not within the exclusive jurisdiction of any court, tribunal, or body. Okay? And for the family court, it has the exclusive original jurisdiction to hear and decide criminal cases where at the time of the commission of offense, one or more of the accused or the victim. Okay, let's say for example sa Sandigan Bayan, oh, procedure to determine whether Sandigan Bayan has jurisdiction. So the offense, whether or not the crime charge is among the violation of the following RA 3019, basta in relation to sa politics, like for example sa plunder, sa anti-money laundering. So that's for the Sandigan Bayan. Yes po, yes po. So another basic is, ano pa ba mga basics? So, let's say for example, mm, sa basics lang tayo kasi yung sasagot mo, basics lamang po. O let's say for example, lupon tagapamayapa ang katarungang pambarangay. So, though the Court of Tax Appeals has jurisdiction over the criminal offenses for the violations of the tariff and customs codes, pero itong lupon tagapamayapa ang katarungang pambarangay, the lupon of each barangay shall have authority to bring together the parties actually residing in the same city. So ang CLOMO is same city or municipality for amicable settlement of all disputes except offenses punishable by imprisonment exceeding 1 year. Okay, that should be below. So offenses where there is no private offended party. Let's say for example, another example, sa libel, di ba? Very familiar. Though kung nabasa niyo sa news, yung yung kay Maris at saka yung kay Anthony Jennings, it falls in line with the Data Privacy Act. Pero let's say for example, um, um, hindi siya libel but data privacy. Let's say for example, let's say for example, mag-segue tayo, na libel siya. So the venue of libel cases where the complainant is a private individual is limited to only either of the two places. So, two places ha, where number one, where the complainant actually resides at the time of the commission of the offense. Okay? And also where the alleged defamatory article was printed and first published, which does not include first access. Okay, that's sinabi yan sa case nila Bonifacio versus RTC Makati. Okay, so let's proceed. Hmm, how about for the hold on. Okay, diretso na tayo. So, let's say for example, dito sa um, rule, ay, sorry, rule Rule 110 or Rule 110. So, sinabi dito sa prosecution of offenses, criminal actions how initiated. So, for offenses where a preliminary investigation is required by filing the complaint with the proper officer for the purpose of conducting the required requisite preliminary investigation for all offenses by filing directly with MTC and also the Office of the Prosecutor. Okay? So Rule 1110, the institution of the criminal action shall interrupt the running period of the prescription of the offense charge unless otherwise provided in special laws. Okay? So as a rule, there is no direct filing of information or complaint with the RTC since its jurisdiction covers only offenses which requires preliminary investigation. So, um, mostly, probably, nakita na natin, probably maraming preliminary investigation bukas. So, if hindi naman marami, but mostly it will reflect on preliminary investigation. Okay, so, but sa case sa Rule 110, so after the filing of the complaint or information in court without a preliminary investigation, the accused may within 5 days from the time he learns of its filing, asks for a preliminary investigation with the same right to adduce evidence in his defense. Okay, so in cases involving special laws, okay, so other cases is not controlling. Okay, mm, let's have an example. Um, so ito, a complaint. Balik muna tayo. A complaint. So let's have example sa Rule 110 sa complaint. A complaint or information is if it states ang complaint is sufficient pag meron siyang name of the accused, the designation of the offense, acts or omissions. Dapat meron siyang ganon. Name of the accused, designation of the offense, and acts or omissions. Okay? So, but the test for sufficiency is whether the crime is described in intelligible terms with such particularity as to appraise the accused. Okay? So, um, the nature of the offense is determined not from the caption of the preamble of the information or from the specification of the provision of law alleged to have been violated, which mere conclusions of law, but by the actual recital of the facts in the complaint or information. However, if there is an aggravating circumstances, whether qualifying or generic must be alleged in the information. So, dapat nakalagay doon sa complaint, information, and considered by the court. That's in the case of People versus Torrecampo. Okay? So it is not necessary to state in the complaint or information the precise date. So it is not necessary na ilagay doon ang precise date the offense was committed, except when it is a material ingredient, if it is very important, which is material ingredient of the offense. Okay, so in offenses against property, if the subject matter of the offense is specific and identifiable, an error in the designation of offended party is immaterial. So not really important. Mm, Sample. Ito, diretso na lang. Duplicity of the offense. Let's say, for example, duplicity of offense. What do you mean by duplicity of offense? A complaint or information. But the exception muna. A complaint or information must charge but one offense, except when the law prescribes a single punishment for various offenses. However, if a single party is imposed, such as when various offenses can be complex or compounded as per Article 48 of the RPC. So, for example, each incident of sexual intercourse or lascivious act is a separate and distinct offense that must be subject of separate information doon sa complaint. So, where a person was arrested, let's say, for example, where a person was arrested for illegal possession of multiple firearms, each firearm should be the subject of a separate information because the law provides for a separate penalty for each type of firearm. This is a case-to-case basis lang. Okay? Mm, okay, ito. An amendment, an amendment is merely formal. Okay? An amendment is merely formal if it serves to incorporate any supervening event that increases the penalty imposed. Okay? So, examples of substantial amendments: change from homicide to murder, change from robbery to robbery in an inhabited place, alleging the relationship of the accused to the victim. Okay. Eto. What do we mean by substitution? Substitution and amendment. Oh, ito. Sige nga. So, what do you mean by substitution versus amendment? Pag sinabing substitution, necessarily involves Substantial change. Substantial change. Okay? Substantial change. Pag sinabing substitution, necessarily involves substantial change. While amendment, while amendment is maybe formal, okay ha, maybe formal or substantial. Either way. Kasi kapag sinabing substitution kasi, must be with the leave of court. And while amendment, it be, if before plea has been entered, can be effected without the leave of court. Okay? Alright. So another venue. Oh, sige nga. Venue of criminal action. So the criminal action shall be instituted and tried in the court of the municipality or territory. Or, let's say for example, where the offense was committed. So kung saan siya, yung offense committed. Or any of its essential ingredients occurred. Alright. Illegal recruitment. Wala na yan. Okay. Anyway, meron naman tayong example later on. I'll give you um, paano sa yung exam bukas. Okay. Okay. So for prosecution of civil action, the criminal action for let's say for example, the criminal action for violation of Batas Pambansa 22 shall be deemed to include the corresponding civil action. No reservation to file such civil action separately shall be allowed. So when civil action may proceed independently, if the offended party waives the civil action, reserves the right to institute it separately or institute the civil action prior to criminal action. Okay, so but the reservation shall be made before the prosecution starts presenting its evidence. Okay, so another tip, top one, eds, you don't have to memorize. Sa dami-dami po ng sections, rules. Let's say for example, articles for other subjects like criminal law, civil law. Um, Huwag na mag-memorize, so huwag na. So it is not advisable to memorize, not even familiarize. Okay? Do not memorize, do not familiarize, but just understand it. You can make your own. Um, just understand. Okay? Kung hindi kaya mag-understand word by word, i-understand mo and get the logic of such sentence, paragraph, or article or rules. So just understand. Kasi kapag na-understand mo yung bawat linya, uh, section, um, you have the higher chance na um, you can answer it, okay, in the essay exam. Okay, so understand. So do not memorize, do not familiarize, but understand it. Paano? Paano mo i-understand? Just by putting more examples for each rule, article, section, paragraph, or sentence. So the more ka magbigay ng examples, high probability or high chance nga mas mataas yung understanding mo for that topic, subject, rule, article, sections, paragraph, and sentence. Okay? Ang technique pala sa Codal is lagyan mo ng maraming examples per line, per sentence, per rule, per article. Okay? So, um, though mahirap siya sa simula, pero as you go along, magiging easy siya. Though medyo matagal, and I tell you, honestly, top 1 Eden, uh, huwag na maraming mga materials. No, you can pass just by your Codal. Kahit na mag-bar exam ka, you will really pass just by maximizing your Codal, by putting more examples, um, putting more situationals. Okay, every rule, every section, every article. Okay? So more examples lang and focus on first caudal. If you have more time, go to your case digest. If you have really more time, that's the full text and annotation na. Okay? Yan. Pero later on, give you the secret kung paano sumagot later on. So, okay, let's proceed with the rule 111. So, eto. Ah, ano nga yung prejudicial question? Okay? Prejudicial question. What do you mean by prejudicial question? So pag sinabing prejudicial question, it means that the elements of prejudicial question are previously executed civil action involves an issue similar to intimately related to the issue to the subsequent criminal. And also the resolution of such issue determines whether or not the criminal action may proceed. So pag sinabing prejudicial question is that which arises in a case, the resolution of which a logical antecedent of the issue involved in the criminal case, and the cognizance of which pertains to another tribunal. So probably this would relate to DreamWorks Construction versus Hanyola. So pag sinabing prejudicial question, it accords civil case preferential treatment and constitute an exemption of the general rule. Okay? Ano nga yung sinabing general rule? If the civil action was commenced before the institution of criminal action, the civil action shall be suspended in whatever stage it may be found before the judgment. Okay? Exemption if there is a prejudicial question, if there is petition. Okay? So for example, in a case for estafa with abuse of confidence. So supposedly, if the authority of one demanding in behalf of the corporation is found to be defective, it is as if no demand was never made. Hence, the prosecution of estafa cannot prosper. Why? Because thus, a separate case questioning the authority of the operation to demand the return of the company vehicle from the accused. This is in the case of people with Arambolo, pero wag lang yan. Okay. Mm, eto. What is the rule? Okay, what is the rule? What is the rule on filing fees in civil action? Sinabi dito, civil action pero criminal to. Pero, dapat kasi, I don't know the reason bakit inuna yung criminal procedure sa inyo. Pero dapat nauna talaga yung civil. Pero kung ikasali yung civil, dapat may civil law eh. Kasi nandoon yung persons of family relations, nandoon yung obligation and contracts. Pero I don't know, maybe your school has the reason bakit inuna yung civil procedure. Kasi pang third year yan eh. Kung higher year, yung criminal procedure. So, ang technique mo, first, focus on what will really come out. Pero mostly you come out, it's on the rule 112, which is the preliminary investigation. Yan talaga, marami talaga dyan. At para may, yung sinabi mo kanina, regarding yung sa DOJ, pwede mo pahapyawin just a few minutes of your time nga basahin. Baka possible din lalabas. Pero I doubt kasi ginamit is the previous rule, which is the rule 112, which is the old one. Okay? Yan. So, what is the rule on filing fees in civil action deemed instituted with a criminal action? When the offended party seeks to enforce civil liability against the accused by way of moral, nominal, temperate, or exemplary damages without specifying the amount thereof in the complaint or information, the filing fees thereof shall constitute a first lien on the judgment awarding such damages, except as otherwise provided in the rules, no filing fee shall be required for actual damages. So for example, in BP 22 cases, filing fees should be based on the amount of the check involved, which shall be considered as the actual damages claim. Okay ha? Mostly, probably lalabas bukas, BP 22. Okay? Filing fees shall be based on the amount of the check involved, which shall be considered as the actual damages claim. Okay? Ito rin, another tip, pagsasagot sa essay. Dapat ang words po ay hindi po manggagaling sa atin. I repeat, ang words ay hindi manggagaling sa iyo, but on the law. What is the law? The caudal, the jurisprudence. So, dapat hindi manggagaling sa atin yung ating words. So, dapat from now on, mag-prepare ka ng mga, let's say for example, mga legal keywords. So, sample ha, legal keywords, yung nabanggit ko kanina. Moral, nominal, temperate, or exemplary damages. Okay, so, yan. Pwede mong ilagay. So, in BP 22 cases, filing fees should be based on the amount of the check involved, which shall be considered as the actual damages claim. All right. Okay, ito. Another pasegue lang. Remember that an administrative case does not raise a prejudicial question. Okay ha? Ang administrative case does not raise a prejudicial question. However, an action for a specific performance, even if pending with an administrative agency, raises a prejudicial question. So according to San Miguel Properties versus Perez, said action is civil in nature that could not be instituted elsewhere except in the uh, realty or HLURB. HLURB. Ang tawag dyan. Oh, yan. Ito, yung favorite mo. Favorite na lalabas bukas. Probably mas maraming lalabas. Ito, preliminary investigation. Okay? So, sa preliminary investigation is an inquiry or proceeding to determine whether there is sufficient ground to engender a well-founded belief that a crime has been committed and the respondent is probably guilty. Hindi pa kasi preliminary investigation pa eh. The respondent is probably guilty thereof and should be held for trial, except as provided in Section 6 of this rule. A preliminary investigation is required to be conducted before the filing of a complaint or information for an offense where the penalty prescribed by law is at least 4 years, 2 months, 1 day, without regard to the fine. Okay? Ito may so sa preliminary investigation, meron siyang let's say for example, mm, hindi siya jurisdiction but ah, iba-iba yung way or probable cause. So, meron tayong preliminary investigation sa executive branch. Meron din tayong preliminary investigation by the judiciary. Okay? So, pag sinabi kasing preliminary investigation, PE, pag sinabing preliminary investigation by the executive branch, what do you mean? It is done by a prosecutor for the purpose of ascertain whether a charge should be filed. Pag sinabing a preliminary investigation by the judiciary, it is done by the judge. And the purpose is whether a warrant of arrest should be issued. Okay? I repeat, sa preliminary investigation, if sa executive branch, it is done by the prosecutor for the purpose of ascertain whether a charge should be filed. While while sa judiciary, preliminary investigation sa judiciary department done by the judge whether a warrant of arrest should be issued. So, resolution for investigation prosecutor. So, let's say for example, eto, motion, motion for reconsideration. Ito, sample na lang. So, motion for reconsideration under sa preliminary investigation. So, The aggrieved party may file a motion for reconsideration within ilang days? Within 15 days. Okay? So, the aggrieved party may file a motion for reconsideration within 15 days. Under pa yan sa preliminary investigation, ha? So, from receipt of the assailed resolution, either finding probable cause or dismissing the complaint. So, if the motion for reconsideration is denied, the aggrieved party may appeal within ilang days? 15 days from the denial of the motion for reconsideration. So, aggrieved party may file within 15 days, pero pag ma-denied siya, may appeal within 15 days from the denial of the MR. So, para siyang add-on, 15-15. Because the party filing a petition for review is allowed to file a motion for the suspension of the arraignment. Though it is Rule 116, pero the case sa Rule 112, so though it is not a Rule 43 petition, di ba merong mga certiorari, right? So, solely on the ground for Rule 43 or 45, Rule 65. So an administrative appeal to the office of the president is not proscribed subject to the following conditions which have to be established by the jurisdiction. So, wag na yan yung sa office. Okay, ito. When warrant of arrest may issue. So, pag sinabing sa RTC and MTC, ilang days? Within, okay, 10 days po. Pag sinabing sa RTC and MTC, when warrant of arrest may issue within 10 days from the filing of the keyword complaint. Yes, from the filing of the complaint or information. Either way. So the judge shall personally evaluate the resolution of the prosecutor and its supporting evidence. Okay? Though he may immediately dismiss the case if the evidence of the record clearly fails to establish probable cause. Okay, pag uh, nag-fail siya, so it would dismiss. Okay? So, pero if he finds probable cause, he shall issue a warrant of arrest for commitment order. Pero, top 1, Attorney Eds, though sa preliminary investigation, kaya nga matagal umuusad yung kaso because of this rule. So, matagal to. Pero, when we go back to reality, matagal pa rin kasi dami pa, matagal talaga. Aabutin ka talaga ng taon ma- para ma-okay yung kaso mo. Okay? So, yan. It would really take a long time. Though, meron ng mga rule na it would, di ba? Ang rule lang talaga sa, uh, di ba? Procedure. Itong remedial law, criminal procedure, or either civil procedure, is to speedy disposition of cases, di ba? Sinasabi nila, speedy disposition of cases daw. Pero aabutin ka ng 10 taon, kagaya kay quote-unquote Bong Navarro, di ba? Tagal yun ha. Oh, nakuha na niya. Pero naku, what if yan yung ma-apply sa atin. So, are you okay with 5 to 10 years na paghihintay? Yeah, 5 to 10 years. Di ba? So, pero itong preliminary investigation, it would really take time. Though, meron ng mga IRs and laws to facilitate kasi ang rule lamang itong remedial law, criminal procedure and civil procedure is for the speedy disposition of cases lamang. Pero, let's go back to reality. Okay? So, 10 days, 10 days, 10 days, 10 days para sa RTC and MTC. Okay. Oh, what if, in case of doubt on the existence of probable cause, the judge may order the prosecutor to present additional evidence within, add-on na naman, plus plus 5 days. Grabe. Plus 5 days. If merong doubt, okay, from the notice and the issue must be resolved for the court. Okay. Though meron ng 10 days, meron ng 5 days, dapat within 30 days, haba-haba na from the filing of the complaint information. So dapat ma-resolve agad. Must be resolved by the court. 10 days, 5 days, mga add-on lang. Pero, ang sinabi ng korte, dapat within 30 days, dapat ma-solve na yung kaso, pero hindi eh. Some would really take time, even months or years. Pero what if, when arrest warrant unnecessary, so accused already detained via lawful warrantless arrest, accused is charged for an offense punishable only by fine, or when the case is subject to the rules on summary procedure, unless he fails to appear when required. So what are the remedies of accused if there was no preliminary investigation? Anong remedies? Okay, anong mga remedies pag ang accused walang preliminary investigation? The accused, ay, PI pala ito, not PE. Kaya pala, sorry. So, ang remedyo dyan is the accused may question the absence of regularity of a PI before he enters his plea, otherwise deemed waived. Court shall resolve not later than the start of trial. So it does not affect jurisdiction of the court or does not impair the validity of the information. Okay? Let's say for example, another inquest. Okay. So let's define inquest. What do you mean by inquest? Inquest means an investigation conducted by the prosecutor in criminal cases where a person has been lawfully arrested and detained without a warrant of arrest. It is informal and summary and its purpose. Okay? Sa inquest, conducted by the prosecutor in criminal cases where a person has been lawfully arrested and detained without a warrant of arrest. It is informal. So informal siya. Yung keyword is informal and summary and its purpose. Okay. Hmm. Anyway, mahaba naman yung chart. Simplify lang natin to. Meron kasing chart. Hold on. Mahaba kasi. Simplified. Ito. The Secretary of Justice or SOJ or from the Department of Justice has the discretion upon motion or motu proprio to act on any matter that may cause a probable miscarriage of justice. Okay? So ang clue mo, if there is a probable miscarriage of justice, the Secretary of Justice has the discretion upon motion or motu proprio to act on any matter that may cause a probable miscarriage. And miscarriage of justice in the conduct of the PI. This action may include, but is not limited to, the conduct of reinvestigation. Okay? So furthermore, a petition for certiorari. So what do you mean certiorari? This is under Rule 65. So questioning the regularity of preliminary investigation becomes moot after the trial court completes the determination of probable cause and issues a warrant of arrest pursuant to sa case ni De Lima versus Reyes 2016. Pero, wala yun. Nagbigay ba ng prof mo ng cases dito? Criminal proceeding? Meron ba? Hmm, Oh, hello? Hmm. Okay, okay. Hmm. Okay, okay. So nakadetect ka na more on merong mga days prescription. So isa rin 'yan sa bantayan mo. So your professor would yeah, tama, tama. Hmm, okay. Good, good. Okay, so isang babantayan mo is yung timing and saka yung date. Kasi crucial din 'yan. Kasi may date talaga, oh. Tapos, oh, so 'pag mahaba yung sa paragraph, basahin mo muna yung question. So, 'pag para easily mo ma-detect doon sa facts. Kasi sa facts po, deceiving talaga siya. It's a distraction ang facts. So, 'pag makuha mo na kung what is the if ma-spot mo yung issue doon sa case, probably you can easily get kung ano lang yung needed facts doon. Kasi it's a distraction talaga, kagaya sa bar exam. So it's a distraction. Well, later on, I'll give you a sample kung bakit ano. Okay, so inquest. All right. So rule 113. Later on, anyway, yung example, yung actual bar question and answer is PI. So later on na lang yun. So okay. So sa rule 113, arrest. Okay. Sa arrest, arrest without warrant when lawful. Let's say for example, in flagrante delicto. Sorry. In flagrante delicto. Okay? Pag sinabing in flagrante delicto, two requisites must concur. The person to be arrested must execute an overt act indicating he has committed, is actually committing or attempting to commit a crime. Okay? Yan for in flagrante delicto. First, overt act, just committed, actually committing, or attempting to commit a crime. And secondly, such overt act is done in the presence of the arresting officer. Wait lang ha. Wait lang. So, pag in flagrante delicto, ito yung clue mo. Dapat overt act siya, just committed, actually committing, or attempting pa to commit the crime. At saka, it is done in the presence of the arresting officer. That's your in flagrante delicto. Ito naman, another word, hot pursuit. Sige, hot pursuit. What do you mean by hot pursuit? Two stringent requisites must concur. Una-una, pag hot pursuit, an offense just been committed. So, nakomit na. The person making the arrest has personal knowledge of facts indicating that the person to be arrested has committed it. So, ang clue mo sa hot pursuit is just been committed and the arrest has personal knowledge. Okay, personal knowledge. Kasi sa rule, when we go to Rule 114, later on, will accuse release on bail attempts to depart from without permission of the court. You may be arrested. Okay? So, for example, say, escape convict. When the person to be arrested is a prisoner who has escaped from a penal establishment or place where he is serving final judgment or is temporarily confined while his case is pending, has escaped while being transferred from one confinement to another. For that example, escape convict. Okay? So, when a person previously lawfully arrested escapes or is rescued, any person retake him at any time and anywhere in the Philippines. That's for Section 13. Okay? So, kasi sa inflagrante delicto, mere suspicion, unreliable information, not not proper grounds. Okay, ito yung clue mo. Kapag mere suspicion lang, at saka ah, yung information mo is not really reliable, okay, not proper on grounds, there should be a presence of more than one seemingly innocent activity from which taken together, which warranted a reasonable inference of criminal activity. Okay? So, bawal ang mere suspicion lang at hindi proper ang reliable information kasi this would not commence. Okay? There was no overt act as indicative of felonious enterprise that could be properly attributed to the appellant to rouse suspicion. Okay. Ito. What are the requisites of a valid warrant of arrest? Valid warrant of arrest. So, ano, ano ang mga requisites for valid warrant of arrest? Unang-una, dapat may probable cause. Kapag sinabing valid arrest, uh, requisites of a valid warrant of arrest, dapat may probable cause. Ito, ang isasagot mo bukas, pag ganito, lagyan mo ng probable cause. Pag sa arrest na type. Okay? So, lagyan mo ng word na probable cause. Determined personally by the judge kasi valid warrant of arrest. After examination under oath or affirmation of the complainant or witnesses produced, and particularly describing the person to be seized. Okay? So sa requisites of valid warrant of arrest, dapat probable warrant, may probable cause which given by the judge and also after thorough examination, particularly describing the person to be seized. Okay, so simplified lang natin yan. Okay. Okay, ito. Ah, always tayo tell yung sa probable cause. Ito ha, take note. For the probable cause for the issuance of warrant of arrest has been defined as such facts and circumstances which should lead a reasonably discreet and prudent man to believe that an offense has been committed by the person sought to be arrested. In satisfying himself for the existence of probable cause for the issuance of warrant of arrest, the judge is not required to personally examine the complainant and his witnesses. Okay? So the judge is not required to personally examine the complainant and its witnesses. Okay? So sa arrest, Ito yung mga legal keywords mo in flagrante delicto, hot pursuit, valid arrest, and probable cause. So, pag walang probable cause, meaning defective na ang iyong ano, arrest or warrant of arrest or not valid. Okay? So, let's go to bail. Okay, bail. Okay. Ano ba ang importante, ang important basic principle sa bail? Pag sinabing bail kasi, it is the security given for the release of a person. So, bail, so bail siya, so dapat release of a person in custody of the law, furnished by him or the bondsman or sa nagbigay ng yung para sa bail to guarantee his appearance before any court as required under the conditions hereinafter specified. Bail may be given in the form of corporate surety, property, bond, cash deposit, or recognizance. Pero mostly cash naman yung sa bill, 'di ba? Pero 'pag wala, pwede property, pwede yung surety, yung sa corporate, puwede rin yung sa recognizance by the court. Okay? Kasi yung bail, the right to bail is a constitutional right. Okay? Yung clue natin sa Rule 114, bail is a right, is a constitutional right. Okay? Pero meron yung mga exemptions lang, yung mga severe non-bailable naman. So the grant of bail requires jurisdiction over the person and custody over the person. Okay? So exceptions po in a matter of right sa bail. A person shall, before conviction, be accorded the right to bail because it is a constitutional right. What are the exemptions? Unless he is charged with ano ang bawal pag walang non-bailable unless it is charged with capital offense. Capital offense and the evidence of guilt is ang keyword is strong. Strong evidence of guilt. Okay? So, though uh, limit naman lang yung bitay but the higher offense which these are non-bailable. Okay? So, because bail is a matter of right in the following situations: before conviction by the municipality courts, after conviction by the municipality courts, and before conviction by the RTC, not punishable by death, reclusion perpetua, or life imprisonment. Because where it has been established without objection that the accused is, let's say for example, sa case ni Bravo versus Borja, 16 years old, 16 years old, accused, convicted, he would be given the penalty next lower than the prescribed law, which effectively rules out the death penalty. It results the petitioner is entitled to bail as a matter of right. Bakit? Because it is a constitutional right. Tapos, bata pa, 16 years old, convicted na for death penalty, but the law rules out death penalty. Okay, so incongruent siya. Okay. So the grant of bail is discretionary after conviction of the RTC of an offense not punishable by death. Ang clue mo lang dito sa um, uh, sa bail rule 114, the grant of bail is discretionary given given that not punishable by ano yun? Death, reclusion perpetua, or yung 40 years above yung life imprisonment. So, it's discretionary. It depends on um, uh, court judge. Okay? So, the grant of bail is discretionary only. Okay. Merong chart dito pero mahaba na. Custody of law. is not required for motion to quash. Uh, Importante ito. When a matter of discretion. So should the court grant the application, the accused may be allowed to continue on provisional liberty during the pendency of the appeal under the same bail subject to the consent of the bondsman. Okay, ito ha. My numbers ito. If the penalty imposed by the trial court is imprisonment exceeding 6 years, okay? Pag imprisonment exceeding 6 years, the accused shall be denied bail. Pag it exceeded 6 years, or his bail shall be cancelled upon showing by the prosecution with notice to the accused of the following other similar circumstances that he is, okay, eto, bail ha, bail. Pero what if recidivist? So, magiging madi-denied. Most like, how much more if 6 years above? If it is recidivist, quasi-recidivist, or habitual, paulit-ulit yung sala, paulit-ulit na kulong. So probably, itigil na yung bail. Okay? Tapos, more than 6 years pa, so it should be denied that he has been privileged escape from legal, okay, ito, escape from legal confinement, evaded sentence, or violated the conditions of the bail without valid justifications. Okay, paulit-ulit na sala, tapos nag-iskapo doon sa bilangguan, at saka um, without justification, so should be denied bail. That he committed the offense under probation, parole. Okay, ito, another example is that he committed the offense while under probation, parole, or conditional pardon. Probably would be denied kasi hindi mo tinapos ang process eh. 'Di ba? Sa probation, sa parole, or conditional pardon. So, yung process, imbis bigyan ka sana ng due process, nako, tinanggal. Tinanggal because uh, uh, nakasala ka, uh, um, nagiging, you commit already the offense, though it's your under probation, di ba? So, uh, another example also, that the circumstances of this case indicate the probability of flight if released on bail, or that there's injuries that he may commit another crime during the pendency of the appeal. So the appellate court may motu proprio or an motion of any party review the resolution of the regional trial court after notice to the adverse party in either case. So the grant of bail is quote unquote discretionary. Okay? By the conviction of the RTC. If an offense not punishable, exemption, death, reclusion perpetua, or life imprisonment. Okay? That's the basic rule. Ano nga yung rule 115 is, what's rule 115? I think sa 115 is not really, I doubt kung lalabas yan bukas. Okay? Let's go to 116. Arraignment and plea. Nag-arraignment and plea na ba kayo? Wala. Okay. Okay, okay. So, eto. Basic principles sa arraignment and plea sa Rule 116. Pag sinabing arraignment, what do you mean? Ang arraignment is the formal mode and manner of implementing the constitutional right. Ito, uh, keyword, constitutional right of an accused to be informed of the nature and cause of the accusation against him. Okay, sa arraignment and plea. because absence of such results is the nullity of the trial. Accused cannot be tried in absentia without being arraigned first. So dapat meron siya dito. So kasi ang duty of the court before arraignment, so ang duty nila is to inform the accused of his right to right to counsel. Sasabihin yan, you have the right to counsel. If wala, sila magbibigay, di ba? Or sa PAW ng libre. Ask him if he desires to have one and must assign a counsel de officio to defend him unless the accused is allowed to defend himself in person or has employed a counsel of his choice. Okay? Paano at kailan ang plea not guilty be entered? Actual plea of not guilty, accused refuses to plea and makes a conditional plea and pleads guilty but prevents exculpatory evidence, the guilty or plea is withdrawn. Because entering a plea of not guilty cures any defect to his arrest. This, however, does not equate to a waiver to his right to question the admissibility of evidence. But what if it's strong evidence? So probably you have the um, delicado, di ba? Because plea for leniency in the imposition of penalty is not conditional plea, but it imposes it is condition to his plea of guilt. Then it becomes conditional. So for example, in the case of people strong, people versus Balisacan, di ba? So there was no valid plea, but double jeopardy may not attach. Okay? Mm. O, paano po ang accused may enter a plea of guilty to a lesser offense? Because we know that plea bargaining, okay? Because we know that plea bargaining is a process whereby the accused and the prosecution work to a mutually satisfactory disposition of case, subject to court approval. Because the accused may plead guilty to a lesser offense. The court may allow such given the following conditions. Wag na lang yan. Mm, ito, what if ang accused plead guilty to capital offense? Oh, what if capital offense? Oh, okay. What if capital offense? What the court should do? Anong mangyayari sa korte? The court is mandated to conduct a searching inquiry to ascertain the voluntariness of the plea, whether or not accused has full comprehension of the consequences of his plea. Okay? Pero pag bigger siya, like the capital offense level talaga, though wala namang death penalty, but level ng death penalty or capital offense is um, require prosecution to prove the following. Dapat guilty ang accused at precise degree of his culpability. Okay? People versus Kamayon. Alright. Ito. Improvident, improvident plea. Oh, legal keyword. What do you mean by improvident plea? It is withdrawn at any time before judgment of conviction becomes final. Withdrawn ha? Withdrawn. At any time. Before siya, ma-judgment becomes final. Because failure to conduct search and inquiry and renders the plea of guilty. Ito. What if nagka, nagka-error doon sa preliminary investigation pa. So the plea guilty is failure because the conduct of search and inquiry is a failure renders the plea of guilty as an improvident one. So convictions based on improvident plea are set aside only if such plea is the sole basis of the judgment. So if the court receives additional evidence, then the judgment may not be set aside, notwithstanding the improvident plea. Okay? So not much with this one. Ito, meron pa pala. Additional. Bill of particulars. Bill of particulars. What do you mean by bill of particulars? Pag sinabing bill of particulars, it is to enable him to properly plead and prepare for trial. Ay, trial. Trial. Pag sinabing sa bill of particulars, to enable the accused to properly plead and prepare for trial. Because the motion shall apply the alleged defects of the complaint or the details desired. Because kasi, ang remedyo lamang po against an indictment that fails to allege the time of commission of the offense with sufficient definiteness is a motion for bill of particulars and not at hindi po siya motion to quash. Okay? Not a motion to quash. I repeat, ang remedyo lamang po for indictment that fails to allege the time of the commission of the offense with sufficient definiteness is a motion for bill of particulars, hindi motion to quash. That's under the case of Rocaberte versus People. Okay? Merong instances there is suspension of arraignment. Ang reason causes is ang accused kay unsound mental condition, may problema psychologically, or may prejudicial question, or petition for review of the resolution. Yan, mga minor problems. Okay. Pwede bang may motion to quash pag under sa uh, plea na siya? Pwede ba? So sa motion to quash, at any time before entering his plea, nasa rule yan ng 117, di ba? Sa motion to quash, before entering the plea, pwede lamang ang motion to quash. Okay, that's rule 117. Because rule 117 says the motion to quash, the motion to quash facts charged do not constitute an offense. The court trying the case has no jurisdiction over the offense, and the court trying the case has no jurisdiction over the person. Okay? Ano? Ang reason, pag motion to quash, pag walang jurisdiction sa person, walang jurisdiction sa offense, at do not constitute an offense. And automatically it is be a motion to quash. Okay? Valid rules. Hold on na. Sandali lang. May tumawag. Hold on lang. Meron ba tumawag? Oops. Parang meron pero later na lang. Okay. Mm, ito. Okay nga, ito. Palagi mo itong ah, palagi mo itong naririnig sa iyong professor or kay dean and yung mga bigatin. Ito, distinguish demur to evidence. O ito. Demo. 'Di ba? Quash. Motion to quash versus demurrer. See? Yan. Motion to quash. I-fold na ko rin. Motion to quash. What do you mean? Motion to quash versus demurrer. What are the, how can you distinguish? Oh, motion to quash versus demurrer. Pag sinabing quash, motion to quash, kailan? Before accused enters plea. O, pwede ka a motion to quash. Pag sinabing demurrer, after prosecution rest. Okay, after na siya, after prosecution rest. Pag motion to quash before mag-enters ng plea. Bakit? Because kailan mag-leave, it is not required. Pero pag demurrer, pag mag-leave na siya, with or without. Okay? So, pag motion to quash, before sa plea, pag demurrer, after prosecution, rest. Ito. Motion to quash, Rule 117. Demur is insufficiency of evidence. Okay? Pag sinabing motion to quash, matters found in the information. Pag sinabing demurrer, outside of the information. Ito, ang demurrer. Ito, motion to quash, not a dismissal of case. Pag sinabing demurrer, amounts to acquittal. Bakit? Outside of information. Bakit? Insufficiency of evidence. Bakit? With or without or after prosecution rest. Okay, that's the difference sa quash and demurrer. Itong quash, before. Demurrer, after. Okay, that's your keyword. If the motion to quash is sustained, the court may order that another complaint or information be filed except if the ground is due to prescription over or double, let's say for example, double jeopardy. Okay? So exception to the rule that sustaining the motion is not a bar to another prosecution. No other complaint or information can be filed if the ground for sustaining the motion to quash is based on extinction of criminal liability or double of jeopardy. Just like in the case of Radaza versus Sandigan Bayan. Mm, wala na kayong pre-trial right? Rule 118? Okay. Ito. Let's try. How about let's try let's try an actual bar exam relating criminal procedure. Okay, try natin answer. Para ma-foresee mo how to answer properly or probably you have an idea how to make a logical answer tomorrow. Okay, let's try to answer this one. Um, okay, okay. Can you see? Can you see naman, di ba? Okay. So this is a criminal procedure bar question and answer. Okay. In a neighborhood bicycle race, Mr. A bumped the bicycle of one of his competitors, Mr. B. So ang competitor niya is Mr. B in order to para maunahan to get ahead. This caused the latter to lose control of the bike which hit the concrete pavement and sent Mr. B crashing headfirst into the sidewalk. So by the time the organizers got to him, Mr. B was, anong nangyari? Namatay. Because nandoon sa headfirst into the sidewalk. So law enforcement authorities who witnessed the incident arrested Mr. A without a warrant and immediately brought him to the inquest prosecutor for the conduct of an inquest. Thereafter, information for homicide was filled with the inquest prosecutor without the conduct of preliminary investigation. So the next day, Mr. A requested for the conduct of a preliminary investigation. So, eto yung mga tanong. So, ang technique mo pala, before mo basahin yung whole, is to read first the, ano, so before mo basahin ito lahat, read this first. Bakit? So that you can immediately identify the relevant facts. Kasi, the bar exam or the law exam is full of distraction. And even your law professors is a distractor and deceiver. So do not be deceived by your, or let's say the examiner. So please read this first. So letter A, is the inquest prosecutors filing the information without the conduct of preliminary investigation proper? Proper ba? Without the conduct of preliminary investigation? Or Mr. A's request permissible? Okay? So kapag ito ang inuna nating basa, probably we can easily detect the relevant facts and we can apply the with legal basis. Okay? Pero sa letter B, is Mr. A's request permissible? This is should be answered by logical explanation. Better if you have um, legal basis for this one. Okay. So since we already read the question, we can try to um, fast read, speed read this question. So let's try. Let's In a neighborhood bicycle race, Mr. A bumped the bicycle of one of his competitors. So letter B, kaya namatay. So this caused the latter to lose control of the bike, which hit the concrete pavement and sent Mr. B crashing headfirst into the sidewalk, kaya namatay. So ang mga law enforcement authorities witnessed the incident, arrested Mr. A without warrant of arrest or without a warrant and immediately brought him to the inquest prosecutor for the conduct of inquest. So kanina may warrant, without a warrant, tapos inquest, and also, di ba, may merong mga keyword. So thereafter, an information for homicide was filled with the inquest prosecutor without the conduct of preliminary investigation. So the next day, Mr. A requested for the conduct of I, okay. So you can second read the question. Is the inquest prosecutor's filing information without the confirmation proper? Is Mr. A's request permissible? So our answer should be, what is the answer of letter A? Is the inquest prosecutor's filing information without the conduct of investigation proper? So our answer is this. Yes. So how would you answer this one? You may follow the bar exam format kasi sa law school is alak method, or you notice it sa iyong mga classmates. Alak method ang gamit. Pero sa bar exam parang naiba na. CLR method na. Conclusion, legal basis, and um, reason from the application. So ganyan na paiba. Pero it depends po kung alak ang gagamitin mo or CLR, pina-bar type. What is important is dapat logical yung pagkagawa. Okay, answer. For example, is the inquest prosecutor without the conduct proper? So, ang answer dito is yes, the inquest prosecutor's filing information without the conduct is proper. So, complete sentence ba? So, probably this would be a, kung CLR method siya, para siyang automatic conclusion agad. Though wala pang legal basis, pero para siyang conclusion agad. That's why it's CLR method, conclusion. Pero kung alak ito, pwede same pa rin. Yes, pero parang dito lang. Is proper. Or pwede ma-shorten ito, is proper. Then, another way, para yung first paragraph mo, since alak man, direct answer or conclusion. Para siyang busog na busog ka na sa first sentence. Ang second sentence mo is the legal basis. Pwede mong ilagay, pakisulat, dapat ganito ang pagbigkas. The case dictates, or under the existing law and jurisprudence. Yan. Okay? Ang legal basis mo, the case dictates, blah, 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 blah. Or under the existing law and jurisprudence, blah, 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 blah. Para automatic, ang galing nito ah. Ah, ang galing ng intro, yung introductory. So, um, hindi siya para mamukhang matalino, but it is one way to signal your examiner, your professor, that you know the answer. Even you know, or you wouldn't know the answer, pero it's a signal siya. So ang ilalagay mo sa second paragraph is the case dictates, or under the existing law and jurisprudence, blah 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 blah. Okay, pero ba, ito parang if kinulang ka ng oras, pwede itong direct to the point. Kasi ang kailangan lang po sa answer is should be direct to the point. That's why it's a one sentence or one paragraph ito. Yes, the inquest prosecutor's filing of the information without the conduct of an investigation is proper. O ito, when a person is lawfully arrested without a warrant involving an offense which requires preliminary investigation, the complaint, o ito, keyword. So, isa rin technique para maganda at saka may meet yung answer mo is lagyan mo ng legal keywords. Legal keywords ang magpapa-increase ng score mo. Kahit balik-balikan mo ang legal keywords sa 4 paragraphs, okay lang basta. Pero dapat po, na-detect mo na out na yung pag-spot mo ng issue, if you know the issue, dapat doon lang mag-revolve, hindi namang pasegue-segue kung saan yung answer. Okay? So always focus sa and spot the issue. Then doon lang magre-revolve yung sentence mo, yung sa issue. What is the issue here? Ano ba yung issue here dito? So, in this case, ang issue is whether or not the inquest prosecutor's filing of the information without the conduct of investigation is proper. So it's a yes. Okay? So without need of such way provided inquest has been conducted. Ito, nilagay dito, Rule 112, Section 6 of the Rules of Court. Pero, to be safe, to be playing safe, wag na pong ilagay yung yung specific rule section doon sa answer mo para magiging safe. Ito, what if, hindi mo alam ang sagot. State pa rin yung conclusion, direct answer. State pa rin yung, pero, ang yes or no mo, nasa pinakahuli. Okay ha? Worst case scenario ha, kapag hindi mo alam ang sagot na yes or no, ilalagay mo ang yes or no doon sa last part. Not sa first sentence, not sa second, but on the last part. Therefore, blah, 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 yes, he is tenable. He is, uh, uh, blah, blah, he is correct. Yan, dapat nandoon sa last part. Para pagbabasa ng examiner, though mali ang sagot niya, pero may laman pa rin. That would be given additional points. So that's a technique. So dapat yung worst case scenario, kapag hindi mo alam o yes or no, ilalagay mo siya sa last part. Pero nabigay mo na yung conclusion at saka yung legal basis para ma-detect ng examiner, professor, dean, or whatsoever, may alam itong batang to. 'Di ba? So that's the technique. Pero ilalagay mo sa second paragraph should be the case law dictates, or under the existing law and jurisprudence, blah 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 blah. Dapat gamit ka ng thus, therefore, and mga legal keywords. Okay? Okay. So ito. Is Mr. A's request permissible? What's the answer? Yes, Mr. A's request is permissible. Bakit? After the filing of the complaint or information in court without a preliminary investigation, the accused may, ito, numbering na naman. Numbers, key. Within 5 days from the time he learns of its filing, ask for preliminary investigation with the same right to adduce evidence in his defense. Itong bar question ito is matagal na ito. Just check with the numbering ha kung tama. Ask for preliminary investigation with the same right to adduce evidence. Rule 112, Section 6 of the rules of court. Okay? Oh, ito, ibang tip rin. Actually, it doesn't matter kung yes or no, including sa bar exam. It doesn't matter. Hindi yan. It's all about how you articulate. Kasi itong sa law is more on may pros and cons. Kaya nga debatable eh. Hindi siya magiging wala siyang versus people versus republic. Hindi siya magiging ganon kung hindi siya pagdedebatihan. So, ang technique pala, top 1 attorney din, it doesn't matter kung yes or no. Dapat pagbasa pa lang na yung dean, professor, or ni attorney, or ni fiscal, maganda ang logic. Ah, alam niya yung ah, saan ginamit yung law o ang batas, which is yung sa caudal, di ba? Whether Rule 112 or Rule 111. So, yan, it doesn't matter kung yes or no. Dapat gandahan mo lang yung sagot mo. Okay? Pero, debatable naman eh, um, yung question. Okay? So, alternative answer. Is Mr. A request permissible? Yes, eto. This is for, ito pala, isang technique pala. I don't know kung na-save po ba yung revised rules for yung sa prosecutor, yung sa journal. Ano ba yan? I don't know kung nakuha ko ba. Parang wala na eh. Aside from you read your caudal, you also read the revised rules of the office, yung sa prosecutor, yung guidelines. Kasi para siyang criminal procedure. So if you can research sa Google, you may find revised rules of yung yung sa Office of the Prosecutor or sa prosecution. Okay, so kasi sa alternative answer, yes, Mr. A request is permissible under 3B, second paragraph to 2017 revised guidance for continuous trial of criminal cases, prohibited motions, a motion for preliminary investigation filed beyond the 5-day reglementary period inquest proceedings under Section 6. So, wag lang maging specific ka para kung gusto mo maging play safe or when preliminary investigation is required under the Section 8, Rule 112 or allowed in inquest proceedings and the accused failed to participate in preliminary investigation despite due notice is a prohibited motion. Okay? So, dapat gandahan mo yung answer. Pero, in your case, dapat yung direct answer, legal basis, application, and conclusion. Pero gusto ko mag-shortcut, CLR method, just like the bar exam. Conclusion, legal basis, and reason. Combination of conclusion and application. Okay? So, don't worry. I'll give you example criminal and civil law bar questions so that for you to study starting tonight until tomorrow. So, focus na the way you answer. Not with memorizing na with the rules. Focus lang sa pag-answer na. Focus na sa pag-answer. And how you construct your sentences beautifully with articulation and how to effectively convey. Kasi yun po ang hinahanap doon sa uh, law school exams or even bar exams. Okay, focus na sa the way you answer. And after this one, I'll give you samples for criminal procedure and civil procedure. Kasi combine na eh. Kasi remedial law. So, i-review mo lang doon. So, huwag ka na memorize. Titignan mo lang. Titignan mo lang, ganito pala ang pagsagot. Ah, ay, bakit maganda yung sagot doon sa ah, suggested answers. Yan. Okay. Okay, na mag-aalas 12 na. So you need to take rest din. So if you like to go beyond or mag-extend ka, I'll give you sample remedial law actual bar questions and with answers. Um, I'll tapos doon ka na lang mag-focus sa how you answer articulation. Kasi tomorrow later na yung exam eh. Focus na lang the way you answer. Okay? Tapos master preliminary investigation kasi maraming lalabas. Okay? So, preliminary investigation. Mostly, lalabas basta criminal procedure. And the bar exam. PI din. Okay? So, that's it. So, huwag lang mag-memorize. Just understand each section. Criminal law. Gusto mo criminal law bukas? Sige, criminal law. Sige, sige. Okay, thank you. I'll send the sample bar questions sa remedial law. Sige, sige. Okay. Okay, para mapag-aralan mo. Thank you. Good night. Good night.